All right, so thank you guys so much for coming out. This workshop is going to be over protection from abuse, the hearing process in Philadelphia County. So this is hosted in partnership with the Free Library of Philadelphia. So thank you, Chris, so much
Yep, no
for sharing
trouble.
your time. And we're going to have our presenter, Thomas Dugan, who I will be introducing shortly. But we're going to first get into a little bit about our organization, Pennsylvanians for Modern Courts. So next slide. So PMC is a nonpartisan nonprofit, and we envision a Pennsylvania judicial system in where everyone is treated with impartiality, fairness, accessibility, and respect. So we basically work to educate all Pennsylvanians about our courts and the best way to navigate them. So we provide a lot of resources for the Commonwealth, and we really want to advocate for judicial reform and just continue to promote inclusion and access to justice. So we have three different initiatives that we use to really push this mission out. We have PMC Shares, PMC Watches, and PMC Listens. So PMC Shares is actually what we do right now. That's our adult workshops where we bring in either a lawyer, judge, or a legal professional to really just speak about a specific topic that either deals with some realm of legalities or court systems or things like that. And then PMC Watches is our court watch program that I lead, where we take volunteers to observe court hearings. And then PMC Listens is our helpline. So next slide, I'm going to get into just some of our upcoming programming. So we have a really busy time in April coming up. We have a lot of different topics that we're going to be covering. We have judicial codes of conduct, April 1st, and then we have threats to the independence, just a wide variety of things. So if you want to check this out, please go on our website, www.pmconline.org, and you can see our wide variety of workshops we have going on in April. And now, without further ado, I'm going to introduce our speaker, Tom Dugan. He is a very distinguished attorney and specializes on this topic when it comes to protection from abuse. And he works for the Women Against Abuse Incorporated, where he is an attorney. So I hope you guys enjoy his wise words and you can learn a lot from this workshop today. I'll let you take it from here, Tom.
All right, thank you for the intro. Yeah, I guess I should start off with a little bit about myself. I am an attorney. I've been an attorney since 2016, but since 2020, I've been at Women Against Abuse. I primarily do protection from abuse orders or cases. I do a little bit of custody too. I also, as part of my job for Women Against Abuse, I'm actually in the protection from abuse courtrooms every day, helping out, pro se litigants, and by pro se I mean litigants without that don't have attorneys. We at Women Against Abuse offer kind of an on-the-spot advocacy and assistance inside the courtrooms themselves, and I'm one of the attorneys that's responsible for doing that. So yeah, I've been brought here today to talk to you guys a little bit about protection from abuse orders and what they're all about. And so our basic agenda is going to be, we're going to start off with some of the most frequently asked questions, some of the stuff we get here, we get a lot. Move on to what to expect at a final hearing. After that, we'll talk about, what happens when there's violations. And then, we'll talk about safety plans, because that's another very important part of my job is not only dealing with the legal side, but, everybody I meet with, we do discuss safety because, we'll talk about it at the end of this, but at the end of the day, protection from abuse, their legal stuff is great. It helps. But a safety plan is also another step that you probably should be taking in conjunction. Because at the end of the day, this is just all paperwork. Safety plan is where you're really going to get into the nitty gritty of keeping yourself safe. So we can move on to the next slide. So what is a protection from abuse order? So protection from abuse order, a lot of people will probably think of it as like a restraining order, or other states call it a restraining order. We call them in Pennsylvania, we call them protection from abuse orders. They are civil orders. So one of the things that I have to, discuss with clients a lot is that, there are two sides in the legal world. There's criminal and there's civil. This is on the civil side, and this comes from the family law division. And it is an order that helps protect victims of abuse. It provides, what protection in the form of limiting contact the abuser to the victim, and that limit can take a lot of different forms, but that is the general purpose, is to limit contact from the abuser to the victim. And then we can move on. Next slide. This is just some stats on the filings for protection from abuse order. As you can see, there's a big dip in 2020. And I think everybody probably has a pretty solid idea of why that was. Everything was online at that point. It was a little bit difficult to file. It was still possible, and that's actually when I was brought on to Women Against Abuse, and we were filing electronically. And but obviously the volume of pre-COVID was not there. It has since been going back up. It's been going back up for a while. I believe it's probably closer to pre-COVID numbers by now. We move on. So this is just a little graph showing you kind of the most common results of what happens with PFA cases. As you can see, the far and away largest bar is that the plaintiff doesn't appear. That is very common. Like I said, I'm in protection from abuse courts every day. I see cases get dismissed all the time, and that's what happens. Is if the petitioner, or basically the one who files to ask the courts for a protection order, does not appear for the hearing, that case will get dismissed. Now, it is dismissed without prejudice, meaning that that person can bring that case back again and refile if needed. And I know one of the main questions I get asked with regards to that, a lot of people will ask if that will be held against them or if that will be brought up. Generally, no, I've never seen it brought up. It is, like I said, it's so common that, I don't think judges really hold that against you. I mean, there are a lot of reasons why people might not necessarily show up. And, a lot of them might involve safety. Sometimes it is not safe for someone to show up at that time. And so I think at this point, the judges have had enough training to understand that this is not necessarily them. It is not necessarily a sign of lack of commitment by the petitioner. It could be a number of things. So generally, no, I wouldn't say it's very held against the petitioner. Beyond that, the other thing I would point out is that the next highest bar is that the petitioner leaves with a final order. So if you'll see that, the situation in which a judge denies a petitioner a final order is on the rare side in terms of numbers and final outcomes. Say that everybody who applies or who petitions the court for a protection order will get one. However, it does show that there's a good chance. The judges generally they favor the side of granting rather than denying. We can move on. And so, yeah, here are the frequently asked questions. Let me just keep going. So, what is abuse? So, the abuse that warrants the granting of a protection order is actually defined by the Pennsylvania statute. It is specifically threatening, stalking, harassing, or abusing. So threatening, threats of physical harm. Stalking behavior is kind of more of a vague or subjective term. It's essentially showing a pattern of acts that would, that somebody would call stalking, showing up in places they're not wanted or not expected. Looking after the petitioner, that kind of thing. Harassment, again, can actually kind of take a lot of different forms depending on the case. It could be anything from, leaving notes, property damage, stuff like that. Stuff I see a lot is car issue, people messing with other people's cars, slashing tires and such. And all that could be, considered harassment. It is like I said, a kind of a more general term. And then abuse is obviously just physical abuse, any sort of physical abuse, including in the definition of abuse is sexual assault and rapes. So they also qualify for protection orders. There is also a separate kind of system that is very similar, so which we call PSVIs, and those are for specifically sexual assault victims. And the remedies, the procedure is very much the same. I believe it's handled with a little more confidentiality given the circumstances. But overall the process is pretty much the same. Also including false imprisonment, kidnapping. Those are also included in the definition of abuse. And false imprisonment could be as much as not letting someone leave the house or not letting someone leave a bedroom or something. It can be as easy as that. And it's not necessarily extended periods of time. It could be for a day or something, and that is still considered abuse under the statute. So we can move on. Okay, so who may file for a PFA? The Pennsylvania law actually limits who can file to a PFA to basically two things: one, a romantic relationship, or two, a relationship by blood. So first, romantic relationship, typically that involves intimate partners. And that covers everything from boyfriend, girlfriend to partners. Any sort of intimate relationship, even something casual, something like that. It also covers a dating relationship. So as little as one date might qualify you to file for a protection order, even if there was no sexual encounter or anything like that. Any sort of like romantic relationship with that person would apply. The other one is a relationship by blood, and that also includes marriage. That is typically family members, brother versus sisters, mom versus dad, that kind of. Child versus son, or child versus parent, something like that. The other tricky one with that, though, is and the one that we see often, or maybe not often, but it's one of the ones I go to is there can be kind of a chain of blood relationship here. I have had situations where a client wanted to file against a former partner's new girlfriend. And if you think about the relationships, there's actually not really a relationship there. They're not a romantic relationship, and they're not filed. They're not related by blood. However, there is some situations in which you can establish that relationship of blood through, like I said, like a chain. So in this situation, the client had a child with her former partner, and the new girlfriend had a child with the former partner. So there was kind of a chain that we made the argument that there was a blood relationship because there is family members by blood. There's two steps there. There's two children there that kind of connect the chain. It can kind of involve some arguments sometime, and it can be difficult. But anything, like I said, any sort of specific blood relationship in any sort of romantic partner would qualify, and we can move on. So what types of protection are available? Now there's the main goal of most protection, or the main facet of most protection orders isn't going to involve a limit of contact. Now there's two kinds of forms that could take. It could be no contact, which means any sort of contact is a violation of that order. If the other party sends a text that says, "Hey, how you doing?" that is a violation of a no contact order, because it should be just like it sounds, absolutely no contact. The other form of limit would be we call protection only. A protection only order, some people will call it a no negative contact order. Protection only order says that person is ordered to stop threatening, stalking, harassing, or abusing, but any other form of contact would be acceptable or not a violation. So under that type of order, as long as the communication is what everybody would consider normal, not aggressive, not threatening, not abusive, then it's fine. In this situation, the parties are allowed to continue to converse. They can talk, text. There are situations in which they could live in the same house. The other parties, though, is ordered to stop threatening, stalking, harassing, or abusing. Okay. Sorry about that. There are a few other types of remedies that can come along with those main no contact or protection only. The other main one would be eviction. So these orders can evict the other party from a property if the two parties share property. These orders are allowed to evict the offending party from the property. It can be for the pendency of the entire order. So we'll get to it a little bit later, but these orders are up to 3 years, so it can be an eviction for them from the property for the entire 3 years. The only thing I would mention about that, the one weird thing that I do see often is that, typically the court will not evict somebody from their own property if the petitioner is not on it. If say the petitioner moved into the defendant's property, but the defendant is the only person who has their name on the deed or the lease or whatever. Typically, the courts will not evict that person from their own property when they're the sole owner of that property. However, that there can be an exception made if the two parties have children. So if if the defendant owes a duty of care to the children or the and along with the mother, in that situation, the judge can evict the offender and leave the children and the abuse victim in the house, even though the abuse victim does not have their name on the property. Other kind of remedies that can come along with these, there can be sort of temporary custody provisions put into these orders. Typically, judges are hesitant to kind of step on custody court's toes. These PFA final hearings are very short. They're truncated. Most probably last less than an hour. That's really not enough time to go through, a full custody hearing. Custody involves, a whole separate set of factors the judge needs to take into account. And so generally PFA judges, like I said, they can order some minor custody rulings. Generally, they keep it to, like basic schedules or sort of exchange spots. A lot of times they'll say any future exchanges have to happen at a police station, something like that. But they really don't get into a full, full consideration of all the custody factors. That would be, something that is more appropriate for the custody court. They can, a lot of times these kind of temporary provisions are meant to just get people to the custody court, or at least, provide some sort of structure until they get, a full order. Next is, weapons. They, any sort of weapon that's used as part of the abuse can be ordered to be relinquished to the sheriff's office. Even, any sort of weapon that's owned by the defendant can be ordered to be relinquished to the sheriff's office. A lot of times those weapons are, if there is a final order granted, those weapons are kept, and that person is forbidden from retrieving them. They are also usually generally forbidden from obtaining new weapons during the pendency of the final order. So a lot of times, protection orders will prevent people from getting from purchasing a gun legally. The other kind of things that we have here, pay spousal and child support, pay reasonable economic losses. It is under law allowed. It is, I would say, generally very rare. I have not seen it really much in my time here. And like I said, I've been here for 5 years. There is some rare situations. I think I have seen it once where there was, an issue of like money owed or something. But there were 2 attorneys on it, so the judge was a little more lenient in terms of what they were willing to order. The issue is that there is not really a method of enforcement through the PFA court for these kind of side money economic issues. So if the defendant, refuses to pay, it can be difficult to enforce it through the PFA court, and that's why a lot of times, for those kind of issues, we generally recommend something that can be handled by the civil court might be better there. And so, but overall, the main things are going to be the limited contact and the eviction. Those are going to be like a lot of things that, that's going to be the primary things the judge is considering when considering these orders. We can move on. So this is just a picture of the family court. It's a 15th and Arch. It's a relatively new building. I think it was built in like 2011 or something. It used to be elsewhere. I did not work at that building. It's across the street from Love Park. You might have seen it. It's a big glass building. It's got a lot of neon colored lights at night and such. This is where all the protection from abuse orders hearings are held. This is also where typically you would go to file. We'll talk about it a little bit later. There are other options that are after hours, but this is, during hours where you would go to file. This is also where you would file custody, divorce, any family law matter. Move on. So what is the process? Okay. So as I said, typically people will file. You start the process by filing your petition, and typically you will do that on the in the family court on the 8th floor. Just as an aside, my organization, Women Against Abuse, we have a paralegal up there most days, up there to kind of help assist in filing, any sort of answer questions, and the paralegal can help with, dealing with the courts and such. So if you are filing up there, keep an eye out for a Women Against Abuse paralegal. But yeah, so it's on the 8th floor. The process is generally pretty simple. There is no fee, so you don't have to worry about bringing money or anything. What will happen is you will go to the filing unit. You will tell them, what you're looking to do, file for a protection from abuse order. They will have a family court worker come and interview you, and they'll take all the information that they need, and that person actually will fill out the form. And then they will file for you. Now, obviously, that can come with some issues. It is very common that, things are misheard, typos are made, maybe misunderstandings and such. Don't worry about that side of things. You are allowed to correct things at the hearing. If a date's wrong, if a time is wrong, something like that, you could just tell the judge that, whoever wrote the petition entered it wrong. Like I said, it happens commonly, but it does happen. The judges know it happens, and they're not going to hold you strictly to what's in the petition itself. I will say it is best to arrive by 8 a.m. The filing, it's the city of Philadelphia does have a lot of petitioners, and it can get very busy. And you'll see through the process, the process takes quite some time. After you file the petition, you'll eventually go down to see a judge by yourself. But this whole process can take a couple of hours. I generally tell people to expect to be there at least half a day, maybe even longer. The earlier you get there, the better shot you got of getting through there fast. The other issue is that a lot of times at a certain point, the filing unit is forced to kind of cut off intakes for the day. What they'll do is they will file the petition, but then they'll tell you to come back the next day for the hearing or something of that nature. And so obviously, if you want to avoid kind of going down there twice, you want to kind of avoid taking more time than necessary, the earlier the better. And then, as we said, we put the number there. There's a 24-hour hotline for information for filing and such. So it's take the number there, but we can move on. So yeah, this is, like I said, normal business hours. You're going to go to the family court. It is generally, I say, arrive as early as you can. 8 a.m. is best. So what happens is you will file the petition, then you will be brought to what we call the ex parte judge. The ex parte judge is a judge that you will see by yourself without the defendant there. You will tell them of your initial kind of what your allegations are, why you're petitioning, and that ex parte judge has the power to enter a temporary order. So any of those kind of no contact, protection only things I talked about earlier, the judge can enter that as a temporary order. The temporary order lasts until the final order. As I said on the last slide, if you arrive after 12, there's a good chance that you're not going to get it filed that day. You're going to have to come back the next day. And so we can move on. We can go to the next slide. There we go. Okay, yeah, this is kind of what I was talking about with the ex parte. After you file the petition, you're brought to the judge. Typically, right now, it is a single judge, Judge Chen, that hears these ex parte hearings, and she's very nice. They typically, there, like I said, there's a lot of filers. The way Judge Chen runs her courtroom is a lot of times she will bring in groups of people and have people, kind of go through them while the rest are waiting in the gallery, the kind of the viewing area. I understand that can be kind of embarrassing for some people. Might kind of turn people off. You are allowed to ask Chen to, if you want to tell Judge Chen that it's a sensitive subject, or you got to relieve, you got to talk about some things that are kind of sensitive. You can ask her to clear the room. Generally, she will do it, especially if there's any sort of sexual abuse or anything like that. But she doesn't do it automatically. You got to ask her. So, I just tell people, just if it's something that you would have a real issue with, talking in front of the other people that are also filing, you can ask them to clear the room. As I said, the Judge Chen will then determine if a temporary order is needed. They will issue, typically Judge Chen will issue, temporary orders that, like I said, they last until the final hearing. Overall, Judge Chen is pretty liberal with the temporary orders. However, there are situations in which she will give what's called a hearing only. In that situation, when in a hearing only situation, that's when the ex parte judge is denied to enter a temporary order. So what basically happens is that person will get listed for a hearing and proceed as normal. However, that person does not have a temporary order in the meantime. And Judge Chen will, or whoever the ex parte judge will generally just kind of go through the basics of the petition. What happened currently, what happened in the past, and then determine if something is needed for the temporary. And so we can continue. So what happens after the temporary order? By law, the final hearing is always listed within 10 days. So typically, if I filed today, I'd probably get a hearing sometime next week. But ultimately, it is always within 10 days. The temporary order it'll be in place and it's in effect. It'll last till the final hearing. Final hearing is where you get to hear, the judge will hear both sides. From here, the temporary order and the notice of the hearing have to get served. And so it is not something that I would suggest the petitioner serve. In fact, the petitioner is not allowed to serve the temporary order and notice of hearing. The most common one is going to be the police or the sheriffs. I believe the sheriffs are still getting a lot of the orders automatically to serve. I have to check on that, but I believe so. But service is pretty much easy. You just go to the police, the local police of where the defendant is. You can ask them to serve it. Typically, they'll just go out and try to serve it. The official rule is anyone over the age of 18 who's not a party member or an immediate family member of a party member. So, no sisters, no brothers serving it, but if there's a mutual friend, that can happen. If there is somebody else over the age of 18 who's willing to sign an affidavit of service, because that's what's going to be required. After that person serves, they sign an affidavit of service. You need to bring that with you to the final hearing. generally, I'm going to suggest almost always going to the police or sheriffs. Like I said, it can be somebody over the age of 18 who's not related. But for safety concerns, I almost always suggest police or sheriffs, unless of course, the petitioner believes that might result in more safety concerns, which is always part of the safety plan that we're going to talk about later. And so we can move on. So legal representation for the final hearing. So the PFA court strongly recommends plaintiff obtain legal representation. We've listed a few organizations that offer legal representation. My organization's the top one, Women Against Abuse. Of course, it's always it always can be helpful to have an attorney speak for you, or somebody who knows these kind of worlds and can help you navigate it, because it can be a little bit daunting. However, it is a process that is done without attorneys all the time. So I wouldn't say lack of legal representation should prevent you or should make you hesitate on filing. My entire job is built around people doing this, without representation. I would say a majority of the cases actually don't have representation. Judges are aware and cognizant of this fact. Generally they're not going to yell at a non-lawyer for not knowing evidence rules or anything like that. So don't worry about that. It is a very straightforward process. I mean, we're going to talk about the final hearings in a little bit here. But overall, it is something that I do believe that, the average person can figure out. But, like I said, legal representation is always helpful. It can always be helpful to have somebody, kind of give an outside perspective, and then be able to kind of navigate these and help you, determine what's the best interest of in terms of getting a PFA. I believe most of these organizations listed provide free legal services. I know my organization does not charge. We do offer representation. If you are choosing to call us, I imagine this is probably true for most of the other organizations. We do need a little bit of lead time before a hearing. We are able to, in order to assign an attorney. Generally, that time is about 2 weeks, because we need to have you go, have that person go through intake, and then that intake paralegal takes it to the committee to determine if we have, the availability and other resources to kind of represent that person. So like I said, we need 2 weeks at least. I'm going to guess most of these others probably do need some kind of heads up. So, the earlier you can get to these organizations, the better. Now, I know some of you may be thinking 2 weeks doesn't really make sense with a hearing that's scheduled within 10 days. We will talk about it a little later, but one of the things you can do is you can request a continuance or a postponement of your final hearing for time to get an attorney. And so, it is still possible, even though these hearings are scheduled within 10 days of filing. So we can move on to the next slide. So how's the abuser notified? This is, like we said, this is like the service that I was talking about a little bit earlier. Like I said, anyone over the age of 18 who's not a party or an immediate party or immediate family member, but I'm going to say the sheriff. I would say go to the sheriff first. It's the safest way. It is, generally the easiest way too, because they know what they're doing. They kind of, they could do it safely. And, in these kind of cases, safety is the number one thing you got to be concerned about. The other thing to mention in service, and I see this all the time, we actually have a paralegal who just helps the service, and she sees it all the time, is that the affidavit of service is the paper that says that the defendant has been notified, must be filled out by the person who signed or who serves, not the defendant. So it is not the defendant who has to sign. The defendant doesn't have to sign anything. In fact, the defendant doesn't actually have to even look at the papers. I mean, it just requires that the person serving them hand it over or identify him and give him, access to the papers. but the person serving is the one who fills out the affidavit of service. The other thing that we see all the time is that affidavit of service should go back to the petitioner. So the petitioner, if you are asking the sheriff to serve it, try to follow up with them to get a copy of that affidavit. If you have the police serve it, make sure you get a copy back, or the original back from them once they do serve it, because you will be asked to bring that to the final hearing, and you'll be asked to present that. And so, a lot of people think, like I said, the defendant has to sign it. A lot of people, or a lot of times the police will, or the sheriffs might hold on to the copy, or the person who serves it might hold on to the copy. And if they do file it with, sometimes the sheriffs will file it with the family court, and that's great. That works. But as a matter of just, ease for your own sake, I would say, get a copy of the affidavit. Because like I said, they're going to ask you for it when you get to the final hearing. And so we can move on to the next one. So what to expect at this final hearing? Keep going. So this is, like I said, this is the final hearing where the judge is going to be hearing you both. So like I said, within 10 days of filing, you're going to be scheduled for a hearing before a judge. Typically, those hearings are either going to be in 3F or 4F. It's going to be on the 3rd floor or the 4th floor in the family court. Almost always they are scheduled at 9 a.m. Except in the case of an emergency petition, which actually, I don't know, maybe I missed it, and I accidentally skipped it. There is a way to file after hours via an emergency petition. For that, you go to the CJC, which is the Criminal Justice Center. It's over on Filbert Street. You could do that after hours, anytime after 5 or anything. However, that is the emergency filing. Typically, they are looking for sort of immediacy in terms of the incident. So they will usually turn people away if something happened longer than 24 hours ago. A lot of times they'll turn people away if there's no physical abuse. So if that's the case, you would just go file at the family court the next day. But if they don't turn you away, if you can file there under the emergency procedures, what happens is you speak to a hearing officer. That hearing officer will issue an order that lasts until the next business day. At the next business day, a normal judge is given all the temporary orders, and then they can issue full temporary orders for the defendants. The only thing with that is sometimes, in very rare cases, and 99% of the time, the judge just kind of stamps what the hearing officer ordered, and it's just an exact copy. In rare cases, sometimes that order changes. Sometimes there's something added or something taken away between when the hearing officer gives it to the judge, and the judge might add something or take something away. For that, you're supposed to pick up the orders on the next business day at the family court. And so we do recommend people do that just so you have a final order of the final copy of the real order that is in effect, because it's going to be the judge's order that's in effect. So yeah, sorry, that is just the emergency filing procedures. But yeah, usually the emergency filers are scheduled at 1 for the first time, but for the most part, people are scheduled at 9. What a lot of people think is that, you get scheduled at 9 is that you'll see a judge at 9. That is not going to happen. The way this works is that they schedule probably, anywhere between 20 and 50 cases for that courtroom that day. And they handle it as they can. And it's not necessarily in any sort of specific order. So just because your case is scheduled at 9 doesn't mean you necessarily see the judge at 9. They handle it. Typically, they'll handle agreements and such first, and then they'll go through trials. But yeah, so at this final hearing, typically, if the defendant has been served, they will appear to either contest or not contest it. Couple of the possible outcomes: dismissals. Like I said, if the petitioner does not appear, that hearing is just immediately dismissed. Withdraws, the petitioner is always free to withdraw it. They are, even after a final order is issued, they can come back to the courts and withdraw that petition. or withdraw that order. In that situation, it's called a petition to vacate. But yeah, anytime before a final issue is issued, the final order is issued, the petitioner can just freely withdraw the petition, and the temporary order will get vacated. We can move on. Continuances. So that's like I was saying, you are allowed to request a continuance for a number of reasons. Basically, a continuance is a fancy legal word for postponement. What happens is a new hearing will get scheduled. The temporary order does remain in place. The one thing I would point out to people is that continuances, when you get a new date for a court date, the first one is scheduled within 10 days. The second one will not be scheduled within 10 days. Typically, they're about a month out at least. The temporary order, like I said, remains in place until the final hearing is conducted. So during that time, the temporary order would remain in place. That person would have protection and a protection order. But yeah, it would probably be like at least 4 weeks out. Sometimes it's up to 6, sometimes even longer, but that's in the more rare situation. Generally, the first request for a continuance is going to be granted without question. And that's by either party, defendant or petitioner. At the first one, that's the hearing that's scheduled within 10 days. I mean, judges are cognizant of the fact that, even though it's scheduled within 10 days, the defendant might not have gotten notice until 1 or maybe 3 days beforehand. Judges know that, to get legal representation, sometimes it takes a little longer. So a lot of times, and, not the layperson might not know the evidence procedure. So that a lot of times people don't come with the correct, or don't come with their evidence, or don't come with correct evidence or in the correct form. And so for all these reasons, the judges are pretty lenient with the first request for a continuance. It's almost always granted. If you start requesting more and more, then the judge is going to want to, got to be a reasonable reason. Primary reasons for continuous requests are going to be either party wants to find an attorney, give them time to do that. The other one is if either party wants time to gather their evidence. Because what a lot of people don't realize is that, most judges will not allow a petitioner to use their phones as evidence. So, text messages that are on the phone, emails or pictures that are on the phone are not going to be used unless that person has printed this thing out. So a lot of times petitioners will have to request a continuance for time to gather evidence. And what that means, or what that looks like, is basically them taking it from the phone and printing it out. For anything that can be printed out with 3 copies. Anything that can't be printed out, like a video, an audio recording, something like that, has to be put on a USB drive and delivered to the courthouse a little bit ahead of time. Each judge has their own procedure. I know at least one of the judges requested at least 2 weeks in advance. Again, that could be a little difficult with the 10 days, but if you request a continuance, that's, generally I advise people to get it to the courtroom as early as you can, because the earlier you get it there, the more chance you have of them, being prepared to show that evidence at the hearing. It is not shared with the defendant prior to the hearing, so you don't have to worry about them sending it to him or anything, or to them. But yeah, generally, mostly it's for either attorney or evidence. The last reason a lot of people request a continuance is if there is an open criminal matter. Obviously with abuse, a lot of times there is concurrent criminal matters that are going forward. When there is a criminal matter for that defendant has what's called the Fifth Amendment right to remain silent. I'm sure probably everybody's heard that on a TV show or something. You have the right to remain silent. What that means in practice is that the government cannot force someone to testify in a criminal matter. The reason that means that the reason I'm bringing it up and to talk about protection orders is that if that person were to go forward in a protection order hearing and testify, anything that person said could be used against them in the criminal matter, because these hearings are recorded. They have a court stenographer taking the testimony and typing it down, and from that is made a transcript. And so, like I said, anything could be used against that person in the criminal matter, which would be a violation of the Fifth Amendment. So to avoid that issue, what happens is the judges will typically keep postponing or continuing PFA hearings until after the criminal matter is resolved. So those are the main reasons for continuance. Or actually, the first one is if that person has not been yet, you can ask a continuance for more time for service. If there's an issue of locating them or getting them to getting the papers, that is typically granted, and they'll give you more time, and still the temporary order does remain in place. So we can move on.
And I just want to say really quick, Tom, we have about 10 minutes left. So we normally open up like the last 5 minutes for questions.
Oh, shoot.
So
Yeah.
to kind of just jump around the slides, feel free.
Sorry. Yeah. I guess I'm a little long-winded.
No, it's very detailed. It's a lot of information to cover.
Yeah. It's a lot. I know it's, but I'll say it now. So while I have the time, if anybody took the number for Women Against Abuse, we can answer any sort of question that might come up here. We can go through this information again. So please give us a call. That is what we are there for, to answer these kind of questions and help people out navigate this stuff. But okay, what to expect at the final hearing? Final hearing. So if the defendant does not show up, you can ask for what's called a final hearing or a final order by default. Essentially, as long as you can prove that person was served and had notice of the hearing, and then they chose not to show up, that judge can just automatically issue the order. Now, typically, they won't do so if that person's in jail or something where they wouldn't be able to come. But as long as that person is free and is not there, typically they'll cut it off by 10 a.m. So if you got a hearing at 9, they'll cut it off by 10. Next one, final order by consent. Part of my job, like I said, I speak with people in the courtroom. One of the things I do is I see if I can negotiate a settlement. Basically, the defendant can agree to any sort of final order, and they can agree without admission, meaning they can agree without admitting to doing anything. But if both parties agree, the judge just writes the order. There is no trial. They don't go through evidence or anything. The judge just signs the order, but that order is an order of the court, meaning it's got the same force as if you had gone to trial and gotten it. The consequences for violations are the same. So we can move on. And then the last one's a final order by a hearing. Like I said, that's where the judge will hear you both out. The basic structure is the petitioner goes first, gives their reasons for needing a PFA, or all the, goes through the filing incident and all sorts of past abuse. They can present evidence. They can present witnesses during this time. When that is done, the defendant will have their time to give their side of the story. Likewise, the defendant is allowed to present evidence, present witnesses, what have you. When that is over, the judge makes the decision. And any of the final orders that I discussed earlier, the no contact, the protection only, the judge can order any one of these. And the maximum is 3 years. So the judge can go up to 3 years. And order, any sort of combination of the protections that I discussed earlier. We can go on. How long can a protection order last? Like I said, 3 years. However, if there are violations of the order, a petitioner can come back and ask that the judge extend it. However, the judge will not do so unless there is violations. So if everything's all quiet for 3 years, unfortunately, the judge is probably going to deny any sort of request to extend it beyond that time. Like I said, temporary orders go till the final hearing. Emergency orders last till the next day when they get turned into a temporary order, which lasts till the next hearing. So we can go on. What can a final order do? We kind of went through a lot of this, restrict gun access, restrict contact, evict person from a home, can temporary custody provisions, can order sort of other monetary compensation, but that is on the very, very rare side. We can move on. So if you are issued an order, keep a copy. My advice to my clients is keep a good copy in your car, keep a good copy at your house. I don't necessarily think it's something that, if you want to run down to check the mail, you got to put one in your pocket. There is a system in which police and law enforcement can look these protection orders up. But as everybody knows, computers don't always work. Internet doesn't always work. So I do always say it is beneficial to have a copy, very accessible. But I think getting a clean one in your house, clean one in your car probably should cover you in most bases. We can go on. What happens if defendant violates? We can keep going, but I'll move on. So, violations of protection orders are a criminal matter. So it is treated as a crime. So typically, you can go through this. Typically, there's two different types of provisions. There's safety provisions, and then there's the other non-safety provisions. Safety provisions are going to be the limits of contact, the limits of weapons, the evictions from the properties. The non-safety provisions are going to be, the monetary stuff, the support stuff. Violations of safety provisions are a criminal matter, so we can move on. But when there is a violation of an order, people have two options: essentially criminal versus civil. Civil is with the family court. It is a very similar process to getting the order in the first place. It's listed for a judge. You tell the judge why you think the person's violated it. Typically, what they're going to think about at the family court is, do they need to change, modify, lengthen, do something to the order? The other option is criminal. That's where you go to the police. You say, hey, I got this protection order, but this person has violated it in X ways. If they feel it's a violation, they'll escalate it to the detective and then eventually to the district attorney. And from there, a criminal case is started where it is treated just like any other crime, burglary, assault, any sort of like that. Arrest warrant is issued. That person's brought to criminal trial. And the possible consequences that person is looking at is jail time or probation or something along those lines. So we can move on. And we can just keep going. I just kind of covered this in summary. So, so yeah, keep going. Yeah, keep going. How am I looking on time? Okay. So yeah, safety plan. We don't have to spend a lot of time on this, but I do think it is very important. It is something I very much talk about with almost every client I come in contact with. The reality of the matter is that protection orders are great, and it is something that is very, very necessary, very important first step. But it is not the only step that people can take in terms of protecting their safety, because I say to people, at the end of the day, protection orders are paper. It's not going to stop him from coming into the house. It's not going to stop him from attacking you or anything like that. And that's where a safety plan comes in. And safety plan can be a lot of different things. It is just basically a personalized plan to address safety concerns in your own life, and it is going to be customized for every single person. So, most of the times it's going to involve, locking doors, locking windows, those ring cameras or cameras outside of the front door. Those are great. One of the things that I spend a little bit of time talking about with my clients is transition times when you're going from your house to your car to your work, your car to your store or house to the store, any sort of periods like that where you're going from one destination to the other. I like to, kind of point out to people, things that they can take into consideration that might help them keep safe. Stuff like, be aware of where you're parking. Parking under lights and near cameras is always great. If it's parking on a busy street, I like that better than alleys. It's all kind of a matter of relativity. Try to avoid, dark parking lots, that kind of stuff. Safety plan could also be having somebody escort you to your car from your job, just walk you out. Safety plan, another could even be, if you're walking somewhere at night, you don't have anyone to walk with you, just being on the phone with a friend. You don't have to talk about anything serious. It could be, day, the Eagles, anything like that. But just having somebody on the phone. And it could even be, discussions with your neighbors about calling the police if they ever see the other party around or something like that. But I do think it's very important, and I think it's important to do in conjunction with any sort of filing for a protection order. I think you should always consider your safety first, and be aware of kind of issues where you might be in danger, because that is the ultimate goal of all cases, is to keep people safe. And so if you are thinking of filing, I'd also urge you to consider a safety plan for yourself. And that is also something Women Against Abuse help with all the time. Something you could call us about. And we are more than happy to kind of sit down with you and brainstorm with you. It's something like I said, I do every day. So I think that's close to the end of the slides. I don't know if there's another one.
That's like the last real slide.
Yeah, there's just resources.
Yeah.
Like I said, I urge everybody to call us or any of the hotlines or anything.
Well, thank you so much, Tom, for this presentation. You did a great job. It was very detailed and informative, and I hope you guys enjoyed it as well. If you have any questions, feel free to just leave them in the chat right now. But if not, I'm going to be sending this PowerPoint and recording of this presentation along with Tom's information in a follow-up email that you guys can look out for. So if there's any questions.
Yes, I am very accessible. I do not mind talking to people. So, feel free to leave my email, and I urge anybody with a question to reach out, email. We can talk briefly. We could set up something where it's easier to talk if we need to talk after hours or something. Just call somebody or get some help if you need it.
All right. Well, thank you so much, Tom. I really appreciate it. If there's no questions, we can wrap up here. So,
All right.
really,
Thank you,
right,
Tom.
cool. Thank you, everybody.
Thank you, everyone.
all right, great. Well, you guys have a great evening. Thank you so much for
Yeah.
coming, Tom. I really appreciate it. You did a great job.
Yeah.
I hope it helps. And anytime you need it in the future, just let us know.
All right.
Great. Thank you.
Yeah. Have a good night, everyone.